Good afternoon, everyone. My name is Dr. Sherry Ann Charleston, and I'm the inaugural Chief Diversity and Inclusion Officer here at Harvard University. On behalf of myself and President Larry Bacow, who's also here with us today in the audience, it's my pleasure to welcome you to the second event in our Community Dialogue series, Bush v. Gore at 20, a retrospective look at one of the most consequential cases in U.S. history. This event is co-sponsored by the Office of the President and the Office of Diversity, Inclusion, and Belonging as part of our ongoing efforts to model productive dialogue across difference for our community by bringing together policy and subject experts from different political viewpoints through a series of events that will allow us to delve into issues relevant to the current moment. Please note that closed captioning will be provided for this event and that this event is being recorded. I now have the privilege of introducing Professor Jeannie Suk Gerson, the John H. Watson Jr. Professor of Law at Harvard Law School, who will introduce our esteemed panelists. Professor Gerson is a respected scholar who's taught constitutional law, criminal law and procedure, family law, and the law of art, fashion, and the performing arts. Before joining the faculty in 2006, she served as a law clerk to Justice David Souter on the United States Supreme Court and to Judge Harry Edwards on the U.S. Court of Appeals for the D.C. Circuit. She's written 3 books and many articles in scholarly journals and general media and is a contributing writer to The New Yorker. Jeannie, over to you.
Thank you. So I am very, very pleased today to introduce this panel. We are joined today by Annette Gordon-Reed and David Boies and Ted Olson. All 3 are actually people who really, really require no introduction. As may be familiar to the Harvard community, Annette Gordon-Reed is a Pulitzer Prize winning legal historian who teaches at Harvard Law School. And David Boies and Ted Olson are 2 of the world's most esteemed litigators. Both were involved in 2 cases to which would be familiar to all of you in this community. Bush versus Gore, of course, which they will be speaking about today, and the case about same-sex marriage that was litigated in the Ninth Circuit. And that was also one of the ways in which the 2 distinguished panelists here today have modeled what I think is very important to this panel and to this event, which is the ability to have opposing viewpoints and dialogue across differences. And so I was charged with also introducing the topic for today, which is the case of Bush against Gore. And I will start first by recalling that I was a law student at Harvard in the fall of 2000. And that November and December felt like a continuous moment of a once-in-a-lifetime crisis. And now, as we gear up for next Tuesday and its possibly chaotic aftermath, I think this is really an amazing, perfect time to think back to the presidential election of 2000, which culminated with the Supreme Court's decision in Bush versus Gore. And in that case, the Supreme Court stopped Florida's recount. And the effect of it was to decide the election for George W. Bush. And at that time, there was talk of the potential for a constitutional crisis. But in retrospect, it appears that it may have been the avoidance of one. So we have all been following the legal fights over voting in the election this fall. And those are fights over what the Constitution and voting rights laws require in the circumstances of the pandemic, given the perceived dangers of in-person voting and the delays in the postal system. And we have seen that in some states, officials have attempted to accommodate pandemic conditions with more lenient voting rules that increase voting options, and parties have sued to have those moves declared unlawful. In other states, officials have attempted to limit voting options, and some parties have sued to object to those restrictions as unlawful. And the courts have been adjudicating these conflicts case by case, and litigants have been recognizing the court's orders, despite extreme partisan disagreement about their merit. So now, starting from next Tuesday, the legal focus is going to move to the counting of votes. And so we'll recall that Bush versus Gore arose in the midst of an ongoing recount of a very close vote in Florida, when the Secretary of State of Florida in late November 2000 certified a win for Bush in Florida, giving Bush enough electoral votes to win the presidency. Then we know that Al Gore sued in Florida court, requesting that the state recount continue, and the Florida Supreme Court ordered a statewide manual recount of undervotes, or ballots for which the machine count had not recorded votes because of hanging chads. Then Bush asked the Supreme Court to reverse the decision. The court then halted the recount in Florida and held that recounting only the undervotes and failing to have uniform standards for counting contested ballots violated equal protection, because it unequally protected each voter's fundamental right. So this decision came down on December 12, 2000, the same day as the federal deadline for states to determine its electors. Over the dissent of 4 liberal justices, the majority said that it was therefore too late to fix the problems with the recount, and that meant that the previous state certification of Bush as the winner in Florida would make Bush the president-elect. So the key thing here that happened next is that Gore accepted the Supreme Court's decision, and right away he conceded the election to Bush. Now, if he had not chosen to stand down and instead further pressed a claim to the presidency, perhaps by seeking other legal remedies or seeking to have Florida send rival Democratic electors for Congress to count, then we might have experienced a genuine constitutional crisis, and it's not clear what would have happened then. But the fact that the election result was accepted rather than remaining at an impasse meant that a potential crisis was averted. And in retrospect, the court made a decision. Gore responded by accepting it, and that meant that Bush versus Gore ended up being crisis avoidance rather than tearing apart the constitutional order. So now we know that the case included a famous disclaimer that the court's consideration is limited to the present circumstances. So what did that mean? Was it supposed to not have value as precedent? Well, this week we've already started to hear some commentary about Brett Kavanaugh's citation of Bush versus Gore in his opinion in the Wisconsin absentee ballot deadline case. And some are worried that justices are prepared to second guess state court decisions on state election law. But if the case of Bush versus Gore stands for a real principle, I think it is that the state may not use vote counting methods that are arbitrary, non-uniform, or unclear, or treat similarly situated voters differently. And I don't think we have reason to assume that that principle should favor one party over another, and it could be used by either party to challenge state voting regularities if needed. So I think that we need to anticipate that even though we are fixated on Tuesday, November 3rd, we need to anticipate a long slog after that date, because many things can go wrong between Tuesday and December 14th, when the Electoral College needs to meet, and January 6th, when Congress will formally certify the result. And if we have chaos from unclarity about what we are supposed to do under the Constitution, and there is a possibility of violence that will haunt the coming weeks and months, of course, lawyers will consider that a failure of the constitutional order. And it's especially worrying in light of polls that show that some substantial portion of Americans of both parties believe that violence is justified if the other party's candidate wins the election. And we're already seeing storefronts in Washington, D.C. being boarded up in preparation for violence. So I see Bush versus Gore as a moment of crisis aversion. And we might also invite you all and the panelists to reflect on whether, on the role of Bush versus Gore in this moment where people are in the mode of crisis. Thank you. Over to you, Annette.
Okay. Well, thank you very much, Jeannie. This is a wonderful occasion to get the chance to see two superstar lawyers talk about a very, very important case. And I wanted to start by playing law professor, and David, to ask you to explain what were the main legal issues. I mean, Jeannie's given us the facts, what happened. What were the main legal issues that were involved in Bush v. Gore?
I think there were two legal issues. One that the court ultimately decided the case on, and one that there were 3 judges who would have supported, but not the other 6. Those 2 issues were, first, the equal protection argument, where the Bush side said that you don't have uniform standards for counting votes. Broward is using a different standard for when you count a vote than Miami. Now, the general standard was conceitedly the same, which was the intent of the voter. But the way that the counties went about interpreting the intent of the voter was different. And one of the things that the Gore side said was that because you have different voting machines in Florida, in 2000 you had 4 different kinds of voting machines in Florida. And it was clear that there were many more undervotes, that is, votes that were not counted, in counties with the punch card machines than were true in the counties with different machines, more modern machines. And so one of the arguments that the Gore side said is that if you don't have a manual count, which is what the Florida law had provided for, then you've got an equal protection problem on the other side. If equal protection applies here, it applies to depriving people in punch card counties of an equal chance to have their vote counted if you don't have a manual recount. And this was an argument that Justice Breyer emphasized in his dissent, but did not win a majority of the court. We also made a technical argument, which was that the argument that was being made very effectively by Ted Olson in the Supreme Court was contrary, not only new and different, but contrary to what the Republicans counsel, not Ted, had argued in the state Supreme Court, where when we had asked for a uniform statewide standard, Barry Richard, representing Bush in that context, had said you can't use the Florida Supreme Court can't set a uniform standard. You've got to leave that up to the canvassing boards. The second major issue, and an issue that I think may have more relevance to this election, the current election, and the equal protection one, was the argument that said the Constitution gives to state legislatures, not to the courts, not even to the legislature in conjunction with the government, like it is when you pass a law, but gives to the state legislatures the plenary power to determine how electors are selected. And the argument from the Bush side was that the Florida courts were changing that law, and that was contrary to the provisions of the Constitution. 3 justices of the court agreed with that. The other 6 did not. Justice Kennedy, during the oral argument, said, well, that's just what courts do all the time. They interpret statutes, they interpret legislative intent. And so that argument did not prevail. But I think you see that argument coming back in the context of some of the cases now where, for example, a court will say, we're going to extend the deadline for counting mail-in ballots beyond the statutory deadline. And the question is that consistent with the Constitution's command that the state legislature have the plenary power? So I think those are the 2 key legal issues. One resulted in the decision. Maybe the other one is going to be more relevant to this election.
Mhm. Ted, do you agree with that statement, with his assessment of what went on?
This is what my problem has always been with David Boies. I listen to him and I find myself agreeing with him. David, as usual, did a very, very good job of summarizing what the issues were and how the case went to the Supreme Court. I'll just say one or two things. They're not disagreements with David at all. The case went to the Supreme Court. The litigation over the recount went to the Supreme Court twice. We argued the Supreme Court, I think the first time was on the 1st of December, and the second time was on the 2nd of December. The first time was a cert petition from a unanimous Florida Supreme Court decision, and the United States Supreme Court was a little bit confused by what the Florida Supreme Court had decided. The issues there, when David refers to the Equal Protection Clause, he is absolutely right. However, we, from the beginning of this litigation, were conflating or overlapping to a certain degree the Due Process Clause and the Equal Protection Clause, because we were concerned and we were complaining about different standards in different places, but we were also complaining about rules being changed, the method of counting being changed after the election on a day-to-day basis or an hourly basis in one county versus another county. So we thought that had implications under the Due Process Clause as well as the Equal Protection Clause. We were also making the argument that the Constitution is clear that it provides the legislature with the exclusive responsibility to ascertain the rules, the timetable, when things should be counted, and that sort of thing, and that the framers of the Constitution specifically excluded the judiciary from making those decisions, or even other government officials at a state level. So those arguments were all in the case. The first time the argument was made, those arguments were made to the Supreme Court. The Supreme Court decided 9-0 to vacate the Florida Supreme Court decision and send it back, and asked the Florida Supreme Court to explain exactly what it meant and whether it had intended to include federal standards for the dates for when votes would be counted and electoral electors would be selected. Then subsequently, as David explained, there was another Florida Supreme Court decision which did not really refer to what the United States Supreme Court had asked them to do, to explain what in the world they were doing. That decision came down in the afternoon of December 8th. The Supreme Court took that case on the 9th, ordered briefs to be filed on the 10th, and there was an argument on the 11th and a decision on the 12th. I think one point worth emphasizing here is that all of the lawyers on both sides of this case were working as hard as we possibly could to do the best job we possibly could to put the best arguments for our side before the court. And I think both sides did an admirable job of that. And Chief Justice Rehnquist made that statement at the beginning of the argument on December 11th, that the lawyers had, under a lot of time pressure, had done the best we could. With respect to both the lawyering and with the decisions of the Supreme Court, under the 35-day time pressure that everybody was under, the two decisions from the Supreme Court, arguments in the Supreme Court, twice within 10 days, none of that was going to be perfect. And there's a lot of ways in which one could criticize the decision of the Supreme Court. 7 of the justices felt that there were concerns under the Equal Protection Clause. And then, as David pointed out, 5 of the justices felt that the timetable was such that the statewide recount that the Florida Supreme Court had come up with on that previous Friday was too late. It couldn't be done, and therefore the voting was to be stopped. Rather than try to relitigate the case all over again, I just wanted to point out some of those things that were characteristics of what was going on all of us trying to do the best we could under the circumstances.
Well, that's one of the things that came to mind when you were speaking, is to wonder, to ask you, did you know from the beginning, did you both have, your teams have some understanding of how to frame the argument, or is it something that evolved over that 35 days? How sure were you from the beginning that you had the right pattern, the right strategy for moving forward?
Speaking for myself, the election was on a Tuesday. We filed our first complaint in the federal court in Miami on Saturday. So only 4 days later. At that point, there had not been some of the court decisions that we subsequently complained about. But I did have in my mind an 11th Circuit decision that had come a few years before, involving a decision by Alabama to change the rules after the election with respect to how absentee ballots would be recorded and counted. And that was an equal protection due process kind of a case. And I felt that we had some arguments based upon what was going on. It was a 4-county recount that the Gord team had asked for rather than a statewide recount. And they had selected the 4 counties that they felt were most favorable to them. So we thought that there were implications of the recount, and we saw the rules being changed and so forth during the process without subjective standards by people that may have had an interest in the outcome of the election. We refined our arguments as time went on with respect to the argument under Article 2 of the Constitution that David alluded to, which was the 3-justice concurring opinion at the end of the day. I hope our arguments got better over time and a little bit more sophisticated. I think that they probably did, but we certainly didn't have it all right at the beginning.
Mm-hmm. David?
I
Were
think,
you sure how you were going to proceed, or?
I think the arguments evolved as we went, and new arguments, I think, were made to some extent by both sides. I think that, I think interestingly, if you look at both the brief and the argument in the Supreme Court, the briefs were overwhelmingly devoted to the Article 2 issue,
Yeah.
not to the equal protection issue. And the argument, the oral argument, was exclusively on the Article 2 issue until Justice Kennedy kept pushing Ted to the equal protection argument, which Ted, as he is a wonderful oral arguer, and I've said many times that it's much better to have him on my side than on the other side.
Uh-huh.
But I think he quickly recognized where Justice Kennedy was going, and then very effectively made the equal protection argument. But I think that if you look at the briefs, and you look at the initial more than half of the oral argument, you see the focus on Article 2 and then the equal protection sort of evolving, because I think it was apparent that Justice Kennedy and perhaps Justice O'Connor were not prepared to go with the Article 2 argument.
Mm-hmm. I remember from that time, Jeannie talked about where she was. I was teaching at that time, and I do recall being somewhat surprised by equal protection. I'd been focused on everything had been focused on the Article 2 argument, and then equal protection comes in, and so it was sort of an interesting twist to all of this. We're thinking back on this time period, even as an observer, it was an incredibly intense time.
Yes.
What was it like being in that moment? Exhaustion, adrenaline driving you? What is it like to be in the pitched battle like that?
I think all of those things.
All of those things?
It was exciting. It was exhausting. It was something that we were dealing with sort of every day, from the time you got up until the time your head hit the pillow.
Mm-hmm.
It was, you were fighting in for canvassing boards, before state courts, before federal courts. You were dealing with the press, because I think both Ted and I believed it was very important that the American people understand what was going on.
Mm-hmm.
So it was, if I hadn't not been a lawyer, I would have been a American high school history teacher like my father was. And so to have a front row seat and be able to participate in this historic thing was very exciting and meaningful to me. But it was also very, it was very exhausting.
Yeah. Ted?
Well, can I add something to that? It was.
Sure, please. Yeah, both
It
of you.
was, it was it was 35 days or 36 days, depending upon what you count. David mentioned his head hitting the pillow. I don't think for any of us, our head hit the pillow very often. And when it didn't stay on the pillow very often. It was what I've characterized as a perfect storm, in the sense that it was a media storm, it was a legal storm, and it was a political storm. It was the most important office in the United States, the most powerful country in the world. Political figures were involved. That was potentially could have gone before the Congress of the United States. The state legislature in Florida was involved. Members of the United States Senate kept showing up on television and offering their points of view on this. The governor and the Secretary of State in Florida were involved to one degree or another. And David mentioned the media. We had an obligation, we felt, and David's team felt as well, to make sure that the American people knew what we were saying, why we were saying it, why we thought that our side or our point of view was the correct point of view, because we knew that one way or another, the outcome of this was going to be a president, either Vice President Gore or Governor Bush was going to be president. We wanted our side to be perceived by the public as having a legitimate point of view and a legitimate place to be there. So it was early in the morning on television, during the day writing briefs and coaching our lawyers. There was something like 50 different matters of litigation going on in the state courts and the federal court. We were in the federal district court. We were also in the 11th Circuit. Between those two Supreme Court arguments, there was an en banc argument in the 11th Circuit that I participated in. So in the course of 7 days or 10 days, two Supreme Court arguments, an 11th Circuit argument. But we were in the media, on the media in the morning, in the afternoon, and in the evening, and also attending to these briefs and legal arguments. So it was a very, very fast process, but it was all consuming. And you're right about adrenaline. I think that's the only way we managed to survive it. Adrenaline kept us going, because it wasn't because we were getting a lot of sleep.
So you mentioned the public and your duty to tell the public what was going on while you were making the arguments you were making, because it's political, it's legal, it's historic. I mean, this is a historic moment, all of these things together. What civics lesson do you think we could draw from Bush v. Gore? I mean, what did the case tell us about the nature of our government and our system of law?
Let me speak to that, and I know David has points of view. We have talked about this, the two of us, a great deal. I think that one of the things that was important is that both sides respected the rule of law, respected the fact that it was incumbent upon us to present respectable arguments to the various courts that we were appearing before, and that this was going to be an outcome possibly. We didn't know from day to day. I should make the point that this was a roller coaster, in the sense that in the morning, one side would have a victory and we'd all be just thrilled to death. And in the afternoon, we'd have a defeat and we thought we were going to be crushed. And then it was the same thing the next morning. This was happening on a daily basis. One of the civic lessons that I took from this, and that I spoke about, I had several speeches that I gave both in the United States and Europe after the election, is that this was so hard fought by so many people with such high stakes. And we wound up in the United States Supreme Court. The United States Supreme Court rendered a decision. Many people strongly disagreed with the fact that the court took the case and the way the court decided the case. But Al Gore, Vice President Al Gore, behaved in a very responsible fashion, it seems to me. And I think he could have continued the fight had he wanted to in one way or another. I'm not sure exactly how, but he didn't. He respected the decision of the Supreme Court. He said so. And the American people, however much they disagreed with the decision of the court or the process, accepted the decision. And people in Europe kept asking me when I was talking about this, how is that? How could that happen? That people didn't go to the streets, that there weren't riots or, as we call it today, unrest and disturbances. It was an amazing tribute to the Supreme Court, and Justice Breyer has talked about and has written about the fact that the Supreme Court often renders decisions that, in retrospect, were not the right decisions, but the Supreme Court is respected by the American people vastly more than the president, whoever that president happens to be, or the Congress of the United States. And that was a very important civics lesson. And the reason I stress it, I guess, is that it's so important today for what might be happening in the next few days and the next few weeks, that the American people accept what the outcome is going to be and the processes that produce that outcome, and we move on and respect the duly elected new president of the new or old president of the United States, whatever the process produces.
Mm-hmm. David?
I agree completely with what Ted said. After the election was over, I was interviewed by a number of reporters from outside the United States, and I was interviewed by a reporter from Russia. And the reporter said, "Can you explain to me what happened here? It's very difficult to explain to people in my country how your Supreme Court selected the president." And I said, "Well, it's somewhat difficult for me to explain it to some of my people too, but I think that is the process that we have in this country for resolving disputes. We take those disputes to court, and sometimes we agree and sometimes we disagree." And he said, "Well, but where is your Yeltsin? Speaking of Boris Yeltsin, who famously stood on the tank to protest, why aren't people out in the streets?" And I said, I think there are two reasons. I think one is that we recognize the importance of the rule of law. We respect the Supreme Court's role in the rule of law. And we recognize that there's got to be a way to make decisions that everybody will then accept so that we can go forward as a united country. Mm-hmm. I said, I think the second reason is that we have enough confidence in our democracy and in our institutions to know that regardless of who is elected president of the United States, there's going to be another election 4 years from now. And who won last time is not going to affect who wins next time. This is not going to be a situation in which the incumbent is able to control the electoral machinery. This is a situation in which if the president that is inaugurated doesn't do a good job, is unacceptable to the American people, that person will be voted out. And I think it's a combination of our respect for the rule of law and our confidence in the stability of our democracy that allows us to unite behind whoever is ultimately elected, regardless of how strongly we oppose that person. This is the most divisive election in my experience, perhaps the most divisive election in the history of the country. Whoever is elected, the primary task, in my view, of that person is going to be to unite the country. Because if he doesn't unite the country, he is not going to be able to accomplish anything else, whether it's healthcare or infrastructure or foreign affairs. Without this country united and brought back together again, we're not going to be able to accomplish any of the domestic or international objectives that we have. Mm-hmm. So I think the very first task of either of these candidates, whichever candidate is ultimately elected, is to unite. I was asked by Tom Brokaw during those 35 days, what's going to happen if you lose? And I said, if we lose, we're going to unite behind then President Bush. There's going to be a president, and all the American people are going to unite behind that person, and that happened. And it's going to be critically important, in my view, that happened in January.
It's an interesting point, because thinking about it historically, that seems a different context. I mean, a lot of water has gone under the bridge since then, and the process of uniting would seem to be important to have that happen even before the election. And there's indications, much more so than in the previous case, because we didn't know what was going to happen in Bush v. Gore. No one would have thought that we would have ended up at that particular moment. But now, this is going to be a really interesting few weeks. Speaking of that,
I actually hope it's boring, but I'm afraid you may be right.
No, I would nice be boring as well, but I don't think it's going to be that way. So speaking of that, can you see Bush v. Gore? You've alluded to some of this before, but specifically having some bearings on what will happen, in the current election. The counting, extension of votes, what other ways might it come into play?
I think it is, my own personal view is that the argument that was made but did not prevail in Bush v. Gore is going to be more significant to this election than the equal protection argument. And I think one of the things that's interesting is if you look at how the Supreme Court has had a number of cases come up to it over the last several weeks. Sometimes it has permitted the statutes to get changed. Sometimes it has upheld courts permitting those. Sometimes it has upheld courts rejecting those. For me, the pattern here is that the court seems to be tending to allow state court decisions interpreting state law to stand. Even when, for example, in Pennsylvania, the Pennsylvania Supreme Court said, we're going to extend the time for counting votes. There was a clear statute that said how long you could take to bring in votes to count. And the Florida Supreme Court said no, because of all these circumstances, we're going to extend that deadline. Supreme Court let that stand. And I think that was the right decision, because I don't think analytically, my personal view, I don't think analytically extending that is any different than extending the hours, which is sometimes done when voting machines break down, when there's long lines. State courts often extend voting hours and things like that. And while this is a matter of days and not hours, I think analytically the issue, is the same. But whether it's right or wrong, I think the court has is thus far been prepared to allow state courts to make those state decisions. On the other hand, the Supreme Court has also come down against federal courts intervening in state elections to make some of the same changes, like extending deadlines and stuff like that. And so I think it's too early to tell, but if you just look at what the court has been doing, and if you look at some of the ways the Chief Justice has reconciled those decisions, there may be a pattern where the court is going to, at least within very broad parameters, permit state courts to interpret state law, but is going to restrict federal courts from intervening in those decisions.
Ted?
Well, I agree with David, at least most of it. The Constitution, both in Article 1 and Article 2, appears to vest the exclusive authority for regulating the times and places and manner of the election and deadlines and things like that in the legislature of the various states. So the question is, when we have a situation like this where people say, well, those deadlines are unfair. We have a pandemic. We have an emergency. People are afraid to go to the polls. The rules need to be changed to accommodate the right of everyone to vote if it's at all possible. Now, who can change if the Constitution says it must be exclusively the legislature? And in one of the states, I think it was North Carolina, the legislature did adopt some adjustments, and then the state election commission or whatever came along and changed that. And is that a permissible change? In another case, as David says, the state courts have adopted changes to what the legislature clearly prescribed. And in other cases where federal courts have been intervening with respect to, it's not just timetables, it's various other things like postmarks and things like that. The question is going to be, is under the Constitution, can any of those agencies, state courts, federal courts, state agencies, governors, whatever it happens to be, change those rules, the authority for which have been vested in the legislature, and under what circumstances? And David may be right that the court will decide that federal courts can't do this. States courts can properly interpret state laws. Federal courts should stay out of it and let the state courts and the states define their own rules. But that means that in some states, votes will be counted up to 9 days after the election, votes that came in by mail. And in some states, they won't be counted if they didn't get in at the time of the election. So there will be a disparity in the outcome. I'm not saying that's an equal protection violation or anything like that, but it will be an interesting anomaly. And the other thing that's happened here, and I guess we haven't mentioned it, but I don't know what it all means, is that 70 or 80 million people have already voted. In this year, more than anything else, we don't really so much have an election day anymore. We have an election cycle that is going back to September, six-week period. Many things change between the days when some people voted and some people finally get elected. I'm going to go to the poll like I usually do on November 3rd. Lots of things have happened between September and November. So people are voting on, in a sense, different situations. And it's interesting also that Democratic voters are overwhelmingly more likely to be voting by mail or in some other method than Republican voters. So there's going to be different counts in different states depending upon when they start counting these votes. And when votes come in, and I just finished on this point, I like the fact, I guess I'm just old-fashioned, I like the fact that except for situations where you're going to be traveling or you're ill and can't go to the vote, that there is an election day. It matters. You go to the poll, you show them some identification, they verify that you are who you are, you cast your vote, and then it can be counted that day or into the evening. With votes that come in by mail, some of them are not going to be coming in until later, apparently, and they're going to be counting at different points. And so you have a process that's going to be attenuated, extended out longer, and you're maybe going to have a different perception of the outcome based upon who's voted on election day and who's voted by mail that gets counted later. And I don't think that's necessarily good for the system. And by the way, under Article 1, the provision in Article 1, the states do have the authority to decide these rules. This is for senators and members of Congress, but they're all on, members of Congress are all on the ballots in every one of these things. Congress can override that. Congress can pass a uniform system with respect to mail-ins and dates, and it may be time for Congress to do, I think I was on the Commission on Uniform State Laws. There's no body that has done exactly that, but Congress does have the power under Article 1 to enact at least some uniform system that might eliminate some of the confusion and chaos that we might be facing this time.
Mm-hmm.
Yeah, I agree with that. Both Ted and I have talked about this before, and we've talked about it initially in terms of voting machines. To try to improve the quality of voting machines that were available nationally. Now, Many states have done that on their own. Florida, in particular, now has uniform voting machines. And they're the right kind of voting machines. They're the optical character recognition machines that are very accurate in counting, and they have a paper trail so that they can be monitored. I mean, one of the interesting things is that Florida gets a lot of criticism for some of the things that happened in 2000. Since 2000, both the Democratic and the Republican parties in Florida have cooperated, and under the leadership of basically Republican governors, has really reformed its voting system so that it has one of the best voting systems in the country. It has early voting. The votes are counted early so that you don't have a long delay after the election process. So it's really had a tremendous reform. But in terms of the time of voting and the delays and the things like that, I think that some congressional action would be very desirable. In part because the very disparity that Ted talks about, like in some states, the ballots are going to have to only get counted if they come in on election day or before. In other times, they may have up to 9 days. That will exist even if the courts stay out of it, because the legislatures in different states have legislated different rules. And that kind of disparity, although I think constitutional, I think is probably undesirable in terms of the anomalies that it creates. And I think a uniform congressional procedure would be desirable. I have a little bit of a question as to whether Congress actually has the ability to do that with respect to some aspects, but they clearly have in a presidential election. But they clearly have that with respect to the time, because that's specifically given to Congress under the Constitution. So they could provide that early voting would start on a certain day, the ballots have to be in by a certain day and have to be counted on a certain day. All of that is clearly within congressional authority.
Well, it's time to go to some questions that have been sent to me here that I see in my chat function. The first question I'll ask, do you think the American public still has the same respect for the court given today's political climate? What impact do you think this will have on the public's response given the potential for litigation following the upcoming election?
David, the hard questions, you get to answer the hard questions.
Well, I think, I mean, that is a hard question. I hope the respect that the American people have for the court has continued. I do think that the controversies over everything from the refusal to give a vote for Merrick Garland to the speed by which the current justice was considered and confirmed, I think has raised concerns among some people in the country. The Supreme Court is not perfect. The process by which we select Supreme Court justices is not perfect. But the Supreme Court has played an absolutely critical role in our democracy and in the expansion of our democracy. And if you look at the landmark decisions in civil rights and human rights and gender rights and the rights of sexual orientation, all of those kinds of rights, the Supreme Court has played an absolutely critical role in advancing, and it could only have performed that role if the American people had the kind of respect for that institution that we do. So I hope that we continue to find a way that the American people can continue to have the kind of respect for the court, because that's critical not only to the preservation of the rule of law, which benefits all of us. It's also, I think, important in terms of continuing our efforts to fulfill the promise of our founders in terms of diversity and inclusiveness and equality.
And I can add one more point to that, is that we put in the hands of the justices of the Supreme Court some of the most controversial and bitterly contested issues that come before us year after year after year. It is true that the process of appointing the justices has become highly politicized. It is not a pleasant thing, in my opinion, to watch the confirmation process in the United States Senate, whether it's Justice Kagan or Justice Kavanaugh or Justice Gorsuch or whatever. It is not a pretty thing to watch. We select some of the most wonderful qualified people in terms of their intellect, their experience, their integrity. No one has ever questioned the integrity, as far as I know, of the justices of the Supreme Court. That system is the wonder of the world, an envy of the world. And what we put before them the most controversial decisions, and they're hard decisions to make. And there's almost always winners and losers in those cases. And Justice Breyer, as I said before, has written about this, that the court has been wrong from time to time. Dred Scott, Korematsu, things like that. And he talks about the institution of the court and how the court struggles to get it right and ultimately usually does. And I think it's incumbent upon all of us to respect that institution, knowing that that institution may make mistakes or may get things that we think are wrong, but that we as lawyers have a responsibility to explain to the American people, to our clients who lose cases, that this is a system that's more important than any of those things, that we have to have respect for that system, and we have to honor the decisions of the Supreme Court. As the Federalist Papers say, there's no power of the purse and there's no power of armies or anything like that. It's only honored for the system that carries the conviction of the Supreme Court and protects us all. And I think at a time like this, it's very important for lawyers to stand up for whatever the Supreme Court does, even if they may disagree with a particular decision.
And I think, just to add one thing to that, I think it's a critical part of that is that we've got to reform the process by which people are put on the Supreme Court. Over the last decades, increasingly, people have been nominated, and I agree with Ted, these are almost always extremely qualified lawyers. But people are put on the Supreme Court not because of their qualifications. They're put on because of how they are expected to vote. The Chief Justice spoke very eloquently about how we don't have Obama judges and we don't have Trump judges, we just have judges. And the belief in that, I think, is critical to our respect for the judicial system. But for that belief to continue, people have got to be put on the court, other than just because they are assured vote. Because when people are put on the court just because they are expected to vote a particular way, that becomes more of a political body than it does a judicial body. And I think that is the greatest single danger to the role of the court that we face in this country.
This is a question for me. Do we need a bigger court? You don't have to answer if you don't want.
What reason do you need a bigger court?
12 for 12 circuits, bigger.
I think here's the problem. The court cannot take enough cases. The number of cases the court has taken has shrunk. But the problem is, the only really way to solve that issue is not to add more justices. It would be to have panels or things like that, and I think that begins to diminish the role that the court has to play. I do think one of the things that's going to be considered at some point is whether it is appropriate to add justices, in part to try to rebalance the court. I think there are going to be. I think that's something that has serious serious issues about it. I think it's going to be something that's going to be debated. I think that it would be ideal to have the court, in my view, be able to take additional cases than it does. I think it takes too few cases, and I think it sometimes takes the wrong kind of cases. I think a lot of the cases that need to be taken for purposes of normal litigation don't get taken by the court. We have many more circuit conflicts today than when I started practicing law. The court declines to take many important tax, commercial cases and other kinds of cases where there are circuit conflicts because either they're not interested in or they don't feel they've got the time. So I think there are some issues there, but I think those are hard issues to figure out how to solve.
Ted?
Well,
no?
I agree with David that the court doesn't take enough cases, and David and I think that whenever our name is on a petition, the court should take that case because we wouldn't be filing it if it wasn't worthy of the court's attention. And the court has substantially reduced. When I first started practicing before the Supreme Court, the court was taking 150 cases a year. Now it's about 75. In the 30s, it was more than that. And there were longer arguments too, rather than just a half an hour per side that there typically is. I don't know the solution to that. There's something like 9,000 petitions or 8,000 petitions and 75 cases accepted. So that's a disparity that David's point is very valid. I for one, think that 9 is a pretty good number. It's enough to fit in the conference room. It produces close decisions, but it would be 6-5 or 5-4 or whatever it is going to be close decisions. I would think that if we start down the slope, it's been 9 justices since shortly around somewhere around the time of the Civil War. I can't remember whether it's 58 or 68, something like that. And President Roosevelt was very, very disturbed, of course, as everybody knows from their history books, that he kept losing cases in the Supreme Court and wanted to change the number of the Supreme Court. The risk of that is that over the course of our history, we are going to have different parties in power in the legislature and the presidency, and the temptation would be, well, our side keeps losing, we've got to add some more justices, and then the other side is going to want to do the same thing. I surely hope that the temptation to add numbers to the Supreme Court because of dissatisfaction with the composition of the court is resisted.
Well, thank you, gentlemen, very much. This has been an enlightening conversation, and as Ginny alluded to at the very beginning, this has been wonderful to see people who were opponents on a case come together and in friendship. You guys have become friends after the case. How did that happen? You just meet and start talking to one another? Was there still points of tension at the beginning?
I think there are still points of disagreement among the two of us, although I think there are far more points of agreement. But I think primarily the friendship grew out of the fact that we each had, I think, I certainly had enormous respect for Ted, for what he did, and for the integrity and way he did it. We were opposite, very strongly opposite in that case, but we both performed our role in the system, which was to advocate for our clients. And I came to know Ted. I knew him a little bit before, but I came to know him well then, and had enormous amount of respect and admiration, not only as a lawyer, but as a person and as a person who cared deeply about this country and its culture and its institutions, and the things that make this country so special. And we and our wives happily get along very well together. And we are both sort of mediocre bikers, so we can go on bike trips and sort of stay together.
I can add to that. I have such enormous respect for David Boies, and during Bush versus Gore, because as I said at the beginning, I would watch him explain and articulate his positions both in his briefs and oral advocacy in the public arena. And I wanted to learn more from him. I wanted to be a part of the culture that he has. One of the first things that happened after Bush versus Gore, I was nominated to be Solicitor General of the United States, and that was very, very contentious for a lot of different reasons, which I won't get into. One of the very first things that happened is that David Boies stepped up and supported my confirmation to be Solicitor General. And there were a couple things that happened after that we don't have time to get into that brought us closer and closer together. When the Proposition 8 same-sex marriage case came up in California, and the potential for a challenge under federal constitutional law to the discrimination that was being imposed on same-sex couples in California, David and I came together to form what we thought was a team of people that his law firm and my law firm and David and I, as advocates, it was a perfect team. It was a great thrill for me to watch David in court. And to be a part of that team. I thought we had the best of all possible advocacy groups, and it turned out that way. And we found after, in addition to the social occasions, working together professionally, I don't think there was ever a time where where there were times when we had different approaches and talked about different approaches, but at the end of the day, there was never a time that we disagreed on what we should be doing and how we did it.
So Jeannie, do you have something that while you wrap up? Any final thoughts from you? Okay, if that's not it, if you're muted.
Oops, sorry.
If
No,
not,
I just wanted to say it's been a real honor and a pleasure to listen to all of you, and thank you very, very much.
thank you. And thank everybody for joining us. This is a wonderful afternoon.
Thank you, everyone. I would just like to have a virtual round of applause for this amazing, amazing panel. Thank you, Annette Gordon-Reed, Carl Loeb, University professor at Harvard, David Boies and Ted Olson for being with us today. This panel between the three of you all has amassed all of the awards that could possibly be awarded for folks in your professions. And we are just really honored to be able to share space and to receive your insights, especially at a time where people are facing such worry about the health of democracy in the face of heightened political polarization and much more. Your insights here today were just beyond valuable to us as a community. So thank you so much for this very riveting conversation. We are in your debt. Thank you again, Annette, for your excellent moderation. And thank you all for joining us today. This is the second in our community dialogue series, and we'll continue the conversation over the course of the rest of the year. Thank you so much for joining us, and we look forward to seeing you at future events. Have a wonderful afternoon. Thank you, everyone.
Thank
Goodbye.
you.
Thank you.